including the treasurer, and it is December 28, 2023. The time is 11:01 a.m. I'm calling this meeting to order. Are there changes to the agenda? Okay, hearing none. Public comment. Okay, hearing none. Our one and only item is reportings by Assessor Bela Kovacs and our elected treasurer, Steve Matheson.
Want to take it from here?
Yep.
All right. Kootenai County Assessor Bela Kovacs has been recording county employee conversations while simultaneously denying the existence of these recordings. I have forwarded to each of you and prosecuting attorney Stanley Mortensen the email correspondence detailing my efforts of exposing this unseemly activity as well as uncovering some of the actual recordings. Bela has disclosed and forwarded to me 15 conversations. It's apparent from these recordings that I am not the only one he has been targeting. In these 15 conversations, county employees, attorneys, and elected officials have been recorded, including an executive session of the Board of County Commissioners. As we all know, Idaho is a single-party consent state, and I'm not exactly sure how to proceed with this information. This is my attempt to simply let everyone know what I have discovered. As one of 9 elected officials entrusted with guarding and protecting records of the county, my questions are, how many other recordings exist and where are they stored? Have any taxpayers been recorded? How can we facilitate the immediate and unedited release of these public records? What steps has Bela taken to comply with Kootenai County's document retention policy 426 to ensure that these audio recordings are available for public records requests, discovery, subpoena, or other lawful investigations? Did Bela provide an executive session recording to his personal outside legal counsel when suing the county? Frankly, my greatest concern involves county employees. As anyone who has worked with Bela knows, he often inaccurately memorializes his personal interactions through email. Any employee who has been reprimanded or terminated based on these emails may want to review these newly discovered public records. With that, I'll open it up for questions. You have copies of what I have obtained. So again, I don't know where we go from here, but I thought it would be important that you all know that you're likely to have been recorded.
I am particularly interested in hearing from the prosecuting attorney.
This is Stanley Mortensen, prosecuting attorney. Does the board have a specific question they'd like answered, or are you just interested in my thoughts?
I'm interested in your thoughts, but I mean, is any of this, in your opinion, at this point, prosecutable?
I don't know the answer to that question yet. I've begun an analysis to maybe answer that question in the future. What I can tell the board is that at the very least, assuming this is true, if there are recordings of county employees, these, in my view, would be documents that are subject to public records requests. And assuming there are going to be a flood of these records requests submitted, it's creating a lot of work for county employees, including my office, to review those, to decide whether or not those requests should be granted or denied. As the board knows, any document that is the subject of a request needs to be reviewed before the request can be denied or granted. And sometimes it's not as easy as reading a sentence or a paragraph or a 5-minute recording. I don't know how long these recordings are. If there are multiple or dozens of recordings and they're half an hour, 2 hours long, these are all going to have to be reviewed and analyzed before a request can be granted or denied. And that's going to cost the taxpayers a lot of money because you're talking about hourly wages, you're talking about salaried employees. Now, normal workloads are being put on pause while these records are being analyzed and these records requests are being
I'm
analyzed.
particularly interested in executive sessions.
And again, I've begun a very brief analysis of that. I haven't come to any conclusions yet, but it's something I'm going to continue to look into. But those are righteous concerns. I don't know that it would be my purview, but I think between Human Resources and the board, the Kootenai County Policy Manual should also be consulted to see if there's violations of policy, even if there aren't, or even if there are law violations.
One of the things that I think we should talk about is that Bela obviously is the custodian of these public records, whether there's 15 or 115, I have no idea. I don't think it should be the burden placed upon the county resources to manage those public records. He has determined a reason, a rationale for wanting those recordings. I would hope that maybe all of the public records requests would just simply go to him and he can manage them as the custodian and determine what should be released to whom and why. And hopefully not put too great of a burden onto Stan's staff. And then, you know, if he receives a few, great. If he receives 200 requests, well, Bela is the custodian. He can manage that the best way he can.
In your opinion, is this limited to BOCC and other elected officials, or he's also members of the public that have been recorded?
Well, I have no idea. I mean, we could ask him, but you know, does he record constituents that come in and have questions? I don't know. Does he record legislators? I don't know. Does he record attorneys that are defending the county in various lawsuits? I don't know. There are a number of employees that are on the recordings he forwarded to me, my staff, his staff, was not disclosed, was not volunteered, was not, well, they were secret recordings. So I can't answer those questions.
I understand, but I would like to know the answer to those questions.
Well,
Not from you,
You
not
can
from
ask
you.
Bela,
Not from you.
okay.
Well, if I may speak again, and I think that's part of the problem with this, potential problem, is as the board likely knows, under Kootenai County policy, it specifically states that under location of public records, and again, I would argue that if these recordings exist, they are public record. Public records should be stored, kept, and saved on property that is owned or leased by the county. All electronic recordings related to county businesses should be saved and stored only on county hardware and software. I can tell the board through my experience, in order to make sure a response to a public records request is as accurate as possible, it's very common for my office to request IT to conduct a search of emails, etc., things that are within county possession like hardware and software, to make sure we're not missing something inadvertently. And if these public records have been kept somewhere other than on county hardware and software, it's going to be difficult for my office or any county department to give a very accurate response to a records request. So I think that's one of the questions that needs to be answered is, assuming these recordings exist, where have they been kept? Have they been kept in accordance with Kootenai County policy? And is the IT department, is the county going to be prevented from responding as accurately as possible?
Yeah, the two big things that stand out to me are obviously the fact that they become public record, and there has to be a way to identify these things so we can turn them over for the public's interest. And the assessor, who is the person who is responsible for that department, should know that. And by creating these documents and not notifying the county, that's a real issue. The other issue I have is the fact that for executive session, there's a reason why the clerk of the meeting exit the meeting, so that there can be discussions that have to do with litigation for the county, employee matters for the county, and they are not meant to have a public record. And if the assessor is recording these conversations, he's creating a public record when there is not meant to be one, and he actually enhances the liability to this county significantly in many cases. And I find that to be extraordinarily troubling from an elected official. And so without getting too much further into it, it probably would be best if the assessor was at least able to come up to one of these tables and perhaps answer for the behavior and why he would be willing to put the county into such liability and risk without making sure other people know. So that's kind of where I'm at with that.
Commissioners, Bela Kovacs for the record, Kootenai County Assessor. I'm not sure I completely understand the question there.
I'll ask you a simple
Let
question.
me ask the first question, because with these being deemed records, they are essentially, I think what I hear you saying, property of the county. And so they are part of official county business. So the first question I have is in the context of this, it is an official county matter. And so there in that context, my first question is, do I have an attorney representing me here?
Do you need an attorney representing you?
My question is, do I have an attorney representing me? And I'm okay with long pauses of awkward silence until I get a satisfactory answer.
Well, what makes you think you need an attorney to answer
I
for your
don't.
own, to answer for your own behavior as a public official?
We have legal counsel here that's obviously been asked to weigh in. Therefore, it appears to be a legal matter. And therefore, in that context, I'm asking the question. I think it's a fair and reasonable question.
If I can weigh in on that, as everybody in this room probably knows, under statute 31-2604, it is the duty of the prosecuting attorney, and I'm speaking of subsection 3 now, it says to give advice to the Board of County Commissioners and other public officers of his county, which would include the assessor, when requested in all public matters arising in the conduct of the public business entrusted to the care of such officers. So under a narrow interpretation of this, unless you are asking me right now, requesting me regarding a specific matter or issue, I'm sitting here right now. If you have a question, then you're free to ask it.
So my question that I did ask was, do I have legal counsel representing me in this matter, in this official county business?
Okay, again, the statute says I am to give advice to public officers when requested. You're not asking for advice right now. You're asking if you have an attorney.
Okay. Okay. Back to your question, Commissioner Matari. Recordings were made based on my reading of what defines a public record as personal notes. I have done it with the intent of capturing essence of information, because there's lots of information that goes on, so that I have facts straight. And I have used it for personal notes in order to go back and recount that information so that I have the information right. We are discovering processes that have been undocumented. That has been the way it's been since I've been here. I will also say that I have concern that actions of the commissioners, and I'm not referring to you, Bruce, and other elected officials have given me cause for concern as to whether or not the conduct and the actions have all been narrowly legal. And I'm going to leave it at that. And that is why.
Now, I understand, and I suspected that that would have been one of the reasons to document your interactions. But typically in those situations, you tell people, I'm going to record this for my own notes. Further, we're given a pen and a piece of paper so we can actually write these notes down as well while we're in the meetings. So my concern more is the fact that the county's liability gets opened up when you create a record and it's an executive session, for example, which is where the elected officials are supposed to be able to speak freely with counsel and among themselves to discuss matters that have significant financial impact, often, with the county. And it undermines the process when a recording is made, especially if no one is made aware of it. And it opens up the liability for the county when it has the legal authority to not have that liability by having the clerk leave the meeting in executive session. And so what I don't understand is why you would expose the county that way to liability as an elected official.
And the answer is I have not. The answer is it's been presented by Steve Matheson, and I believe, as you're recounting right now, that in the context of it being plural, meaning more than one, I will tell you that no, it is not a correct statement to say that executive sessions in the plural, many of them, I have been to very few executive sessions, very few.
But we don't know. You see, you never made aware to
Yeah.
people that you've been doing this.
Well.
So, it was only, I think, through happenstance that the treasurer requested it. And you just happened to have provided something, which I presume you did because the law would require you to under these circumstances.
I obtained a legal opinion, and I provided.
I'm sorry, what?
I obtained a legal opinion as to whether or not these constituted public records, and so I responded to Steve accordingly.
Yeah. So, and that's
My
the
initial
problem.
response to Steve was with the understanding that these were personal notes.
So how many recordings do you have of other meetings with personnel, other elected officials? How many do you have?
I don't have a number. I don't know.
It's more than you can count right now?
I have not counted it. It's not more than I can
That
count.
many? Okay. Okay. I'm extremely disappointed. And I presume you probably have recorded interactions between me and you, which I don't have a problem with. I think it would be probably an enlightening recording for people to listen to. But, I'm disappointed. I certainly expected more from you. We're supposed to work together.
Well, as I said, it was done for the reasons I've given you.
Yeah, but you could have at least given people that courtesy to say, for my own personal notes, for my own ability to be able to, reference
And I have done that on
conversations,
occasion.
But not with me, I know that.
And I have done it on occasion.
But not with me,
Not with you.
yes.
Not with me.
Not with you.
So what occasions have you done it with, just out of curiosity?
There was a time that I recall for training purposes where,
With another elected official?
no,
Okay.
an employee.
Did you
And
do
there
it-
was, and
did you
if
do
I
it
may
with
finish,
Leslie?
I'm answering the question, where there was a significant number or significant amount of information that was being given to me in a very short span of time. And I said, I need to record this because you're talking about things that I have no bearing on, and the words and the terms mean something to you, but they don't mean anything to me. And so I said I was going to record it. and no objection, and so I recorded it.
Any other ones?
Any other ones?
Or,
What?
or you gave people notice that you were going to record? I mean, so we have one.
I don't recall.
Would you provide us a list of the total number of recordings and those that, you know, how many you have?
Yeah, what I would like to say is, and I'd like to add that I have made it known that I've made a request for an investigation. I am cooperating with the outside agency. I have sought guidance and input in terms of what I can and ought to and should share and when and how, and I'm waiting for responses on that. My intentions and my plans are to make this part of that investigation.
What about us?
I don't want to do anything that would inhibit or compromise the investigation.
May I just comment just for just 1 minute? Bela, you're in receipt of the email. I'm assuming the investigation you're referring to is the Idaho State Tax Commission, and there was an email sent to you, as well as a number of other elected officials by Commissioner Paul Woods, Idaho State Tax Commission, that basically said that your complaint is not a valid complaint because you didn't sign it. And it was much too broad, and that he was asking you to seek other services. Now, are you suggesting that you anticipate revising your complaint and actually signing it? Or is there another investigation that you have instigated that you want to hide behind by not divulging this information?
Well, I'm not hiding behind anything. I don't recall the email that you're referring to. I do recall getting an email from George Brown. Excuse me?
We all got that email he's talking.
Okay, well, I got,
Let me just read, just for.
well, if I may finish, I am responding. I do recall getting an email from George Brown that pretty much said exactly what you're saying. And I was, in that email, I do recall being asked to make a phone call. And I did that, and I've made multiple phone calls. And I have not gotten a response back. Now, what I will say is we know that the Tax Commission has gone through some changes in terms of personnel, and they're short on personnel. And with the timing of the year being what it is, our focus and my focus has been on the rolls, and so I've not followed up. But I did follow up initially twice to that email. I believe it was the email from George Brown. I put calls into that, and my intention is to follow through on that. I do not view the investigation as being, although I initially made it under, I verbalized it under, or I wrote it under Idaho Rule 120. My intent was not to constrain it or limit it to that. I believe the authority of the Tax Commission is broader than that if you read the statute. And I did respond to this already, which I copied Steve Matheson on. And so my intention is to follow through on that.
Just to point out the obvious here, it was addressed to Bela, Kovacs, Jennifer Locke, Bill Brooks, Bruce Matari, Leslie Duncan, Steve Matheson, Jeff McCrae, Paul Woods, John, I can't pronounce his name, George Brown. It was dated December 22nd, 2023 at 3:07 p.m. And in it, if you'd like, I can forward it to you. It basically says it was not a valid complaint because you didn't sign it, and it was much too broad for them to even consider. For your information, I am in the process of actually submitting a valid 120 complaint that I will sign, and it will be going out early next week. So the Idaho State Tax Commission will have the opportunity to at least evaluate a valid complaint and then determine whether they're going to come up and try to help fix the mess that we find ourselves in Kootenai County.
And I do support that, and that was initially my request, is to have the Tax Commission look at all processes within the Assessor's Office, but not be limited to the Assessor's Office alone, because as we all know, we have issues here with the computer system, with various processes. And my objective since day one was to get these processes cleaned up and resolved.
As just a courtesy, obviously, we're getting off target. This is supposed to be talking about secret recordings by the Assessor Bela Kovacs of county employees. So I'll turn it back to the chair to
Can I?
find out where we go from here.
I have a few more questions. Just now that we know that you have these recordings, I think you were probably under obligation to turn them over because they're public records so that they can be categorized. I don't believe that you are entitled to keep public records from the county.
So who is the custodian that I would turn them over to?
I believe it would be information technology because they're electronic.
I don't know if
That's-
James is here. I don't think James would want to become the custodian. I mean, this is going to be a mess. And I think what we need to do is maintain the custodian as Bela. I think it's a totally appropriate question is, okay, how many are there? Who are the recordings? Those are simple questions. But Bela has chosen to use an off-site storage facility for county records. And now I think he needs to navigate it back to compliance with our policy. And I'm suggesting maybe not burden IT or legal with that process.
The offset storage site that Steve is referring to was given to me by IT, and that was the one that I used in response.
For this purpose,
For this purpose.
So IT was aware
that's
that
not
you
what
were.
James is going to say.
No. When you say for this purpose, what I'm referring to is your request to give you the documents, and that's what I did.
Have you destroyed any recordings?
I will say that there are some that I've listened to that were inaudible, and I deleted them.
But
They don't always pick up.
But they were public records, though. I mean, they were a recording, and it was a recording that would be like any other recording, and so you destroyed that.
I didn't destroy it. There was nothing there.
deleted it.
There was nothing there.
Can you prove that there was nothing there?
Is it possible that the recording couldn't be picked up on the microphone because it was in your pocket? Is that a possibility?
It's possible, or
Yeah. You know,
I don't know. I don't know the answer to that question.
do you think it's right to record people who are unaware that they're being recorded?
I record, as I've said, I gave you the reasons why I did it.
Yeah. See, here's the thing, and this is just something I learned a long time ago, so maybe it might be something that you can consider in the future. But an attorney that used to work in the Reagan administration told me, there's 3 questions you ask. Is it right? How will it look in the papers? And is it against the law? And depending on the sequence that you ask those questions tells a lot about the kind of person you are. If you ask if it's right and the answer is no, you don't have to worry about the other 2 questions. If you start off with, is it illegal? And the answer is no, then it tells you how that person thinks. And so that's my concern here, is that you can't say that it's wrong to record people without their knowledge. And there really is no intent here. To what end? With it, if you want to document for your notes, have at it. Just say, hey, folks, for my own notes, I'm going to record so I can revisit. I certainly don't have a problem with that. I frankly don't even have a problem if you're going to record me anyhow. But I would always appreciate the benefit of at least giving the courtesy beforehand to know. And that's why I just feel so disappointed, because I am an advocate of your success because it means our success. I'm an advocate for everyone to succeed. But it's hard for me to wonder, how much you want us to succeed when you operate under the guise of, I want you, Bruce, to trust me, but I'm recording you, perhaps, because I don't have confidence in you. And that's where I feel so let down.
Well, there are reasons for that, Bruce, that I'm not going to go into here.
Well, but they don't
That will
have
be
anything
part
to
of,
do.
that will be part of the investigation.
They don't have anything to do with me. Most of your issues were before me, I trust. Unless there is an issue with me, in which case I would certainly invite you to say that, because you and I have had enough conversations that if there was an issue, I would have hoped that you would have brought that to my attention so that we
Well,
could.
but that's a separate matter, but I think we're working fine together now.
Okay.
Yeah.
Okay. Well, that's what I have to say. So I appreciate the board giving me an opportunity to ask some questions here.
I'd like to know not only how many recordings there are, but how many people you've released the recordings to, whether they be council or whoever, and who has requested them in the past. I mean, I have a responsibility to ICRIMP, so now I get to reach out as a board member and say, look what Kootenai County is facing. So I get to do that now. I'm kind of disappointed in the fact that you have talked about mending relationships with employees in your office. So I'm not sure how they're going to be going forward, knowing that this has occurred. Do you plan on continuing to record your employees?
I will definitely, if I record, I will speak about it beforehand.
There are legal ramifications for releasing executive sessions. So I definitely want you to be like criminal consequences. So please be aware of that and do not release any executive sessions without going through Stan's office. I don't have anything else.
Does anyone else have any comments or thoughts?
I would ask the board to direct the assessor to take every effort to preserve all recordings and all hardware that was used to store those recordings, whether it was hardware provided by the IT department or something the assessor bought on his own.
Can I ask, does that hold the same legal weight as your office providing a preservation notice? Because it is a legal matter.
I'm certainly happy to direct the assessor to do that myself. I just don't see any harm in the board doing it as well.
Yeah, because this is a discussion meeting, but
Sure.
we could probably put a letter together. Thank you.
Hi, I'm Jill Smith. I'm the Chief Deputy Treasurer. Bela. When I first came to Kootenai County, I had such high hopes for the successful collaboration between our offices. You may remember that we started communicating even before my first day at work. I am going to reiterate what the commissioner said and say I'm so incredibly disappointed to find that you have secretly been recording other elected officials and employees, including me. Have you also videotaped these meetings? You're officially saying that you have not videotaped?
I've not videotaped. I don't have the means to videotape.
While Idaho is a one-party consent state, I would argue that most employees have an expectation that's reasonable of privacy when they're communicating with an elected official. While what you have done is legal, in my opinion, and this is just my opinion, it's not moral, it's not ethical, it's not respectful, and it does nothing to establish or rebuild trust with the departments and the people that you work with.
This is our public comment portion. Are there any other public comments?
I'm Aubrey Hollenbeck for the record. I am a past employee of Kootenai County. I have a question for Bela if I can ask it directly. Is that fine? Did you record me?
I'm sorry, I didn't, could you repeat that?
Did you record me?
I believe I may have.
I'm pretty sure you would know if you did or did
Yeah,
not.
well, you have my answer. I don't have them committed to memory. I'd have to go back and review. I believe I
Okay.
did.
Can I ask another question as well? Have you recorded the office without you being present?
Absolutely not.
Okay. You have that for the record, I guess. Also too, am I able to ask, did you record it on your phone or another device? These recordings for your educational purposes?
I'll have to review that.
You don't know? That's a question.
I've answered the question.
Okay. I too am very disappointed, as one now community member, as an employee of the office. I believe that this is extremely unethical. I also, for the record, was never informed that I was being recorded. I was never asked. It was never mentioned to me. And I would be probably one of the people that you recorded for information on the system. So that would make sense to be recorded, which I would have been fine with, but never was brought to my attention. And due to what you brought up earlier in regards to the system, I just would like to make a comment while I have this moment. The system always worked before you. And we made it work. And I'm curious how the next rule is going to go. I hope it's not late, but I'm just saying, if you brought in so much to help the system, if you've asked me, you've brought more debt and expense to community, more layoffs, which is an expense to the community, people retiring before they were meaning to because of you. And to me, that's not helping the system if, again, you just made it worse on all aspects, for the record. Thank you.
I do have a comment, and it's really more of a question that we probably need to look into. You know, as someone who has had employees and has drafted their own employee manual, one of the things that has to be in an employee manual is that it mentions that employees may be electronically monitored, especially in an environment where calls are recorded and things like that, which I'm not suggesting is in the county, but where with my own private business. And the employees must acknowledge these things. And so I would like to know if we have such a phrase in our employee policy manual that people are made aware and acknowledge that they may be electronically monitored within the office place. Because if we're recording employees, then they need to be made aware of that. And again, that's another one of those liability issues. So, you know, I think that's really part of the problem and why I've been so disappointed in this, because just the legal mess that gets created when people are doing things without others' knowledge and certainly consent, that can happen as a result of that. So I do hope that that's something we can find out quickly and mitigate that.
Anything further? Okay, any other public comment? Anybody online?
Woman.
I'm sorry.
Just, sorry for the record, Candace Braun, and I am a county employee, but I'm also a taxpayer, and one thing I was kind of concerned about. I know a lot of times we'll go to our elected officials and we'll ask them personal things. Did you ever record conversations about personal things on employees? Like things they were going through or?
Business.
Okay, last call. Anybody on the phone? No? Okay, 11:40, meeting adjourned.